Are trust companies and asset managers who present themselves as settlement planners or structured settlement experts properly disclosing potential conflicts and compensation when they pitch asset management as an alternative to the traditional structured settlement product? Hi, this is Mark Wallstrom, and I'm back again with another edition of the Settlement Channel Commentary. Now, as someone who has for over 30 years been totally immersed in the structured settlement and settlement planning world, during that time working exclusively with injured parties and trial lawyers, I've been around long enough to see just about every good and bad investment idea that can be pitched to a law firm or to an injury victim. Now, while I could write a book on the bad ideas as well as the sloppy planning that I've seen over the years, what I'm focusing on at the moment is a new trend. You see, I am witnessing almost weekly many firms and individuals representing themselves as settlement planners who are not just offering traditional structured settlement programs, but now increasingly are partnered with trust companies, asset managers, independent registered investment advisors, and other organizations. And as a result of these various business affiliations they have, many are being less than clear about what hat they are wearing when they're pitching their services to injury victims. Often while strongly suggesting the claimant avoid a structured settlement annuity and instead focus on these alternative investment options that they're showing to these clients. Now, it's important to note that with the patchwork of financial service companies, the settlement profession is governed by a mixture of rules, regulation, compliance, and oversight, which if not clearly explained or disclosed to plaintiffs, could lead to excessive costs or loss of liquidity or poor coordination with governmental benefit plans and other issues that put the financial future of injury victims at risk. Now, in the interest of time, I'm going to list just 3 key issues in brief, but rest assured, in the future, I'm going to be doing videos that will be addressing each of these conflicts or disclosure issues in their own separate segment. Well, first of all, did you know that a structured settlement annuity agent has almost zero oversight and is not required to act under the fiduciary standard when presenting a structured settlement annuity program? The settlement annuity transaction has been specifically exempted from the NAIC rules governing suitability, disclosure, compensation, conflicts of interest, and other key items that govern every other annuity purchase that an individual may make. And while a person must be licensed as an agent with errors and omissions coverage to be in the profession, virtually all the rules governing other annuity sales typically don't apply to these very important financial transactions. So this is the first key point to keep in mind, and as a trial lawyer, you need to know the person presenting this proposal is not bound by many of the disclosure and compliance rules other financial transactions require. In fact, there is currently litigation against AIG and the settlement profession hinging largely on the issue of undisclosed commissions and their impact on settlement returns. So this matter of who gets paid and who they're working for is not strictly an academic one. Number 2, are you aware that someone can be both a registered investment advisor who's bound under the SEC rules and certain fiduciary standards, can also at the same time recommend products or services which are not bound under those rules? This is the "what hat are you wearing now" question that so few trial lawyers and injury victims even know to ask. You see, the SEC has stringent requirements for those acting as an RIA, registered investment advisor. But if the planner switches hats to act as an agent or representative for an investment advisor, or that planner is also selling mutual funds, insurance, annuities, or other alternatives, each of those recommendations comes with a very unique and different set of rules, regulations, and standards, many of which do not require a fiduciary standard to offer it to the client. It's confusing, isn't it? So if you're confused, can you imagine the poor client who has little or no experience in investments trying to figure all of this out? The third issue I want to point out is that there are trust companies and investment advisors out there in the settlement profession who are charging an asset management fee for their services, which is fine. But they're also putting the investments of the trust into load or commission mutual fund shares. In fact, I've seen proposals saying funds under management will be invested in C shares. And what that's telling you is that there will be another 1% charge annually that is being paid to someone in that process. It's a classic double dip. You see, the rule of thumb is and should be that in a trust or RIA account, to never have load funds, but always instead have institutional shares, which are bare bones pricing, and they should be held as they pay no commissions. However, I've seen RIAs and trust companies doing exactly what they should not be doing, but because they disclose the use of these commission products in their sales literature, it's certainly not illegal for them to do so, even though it's unwise and not great for the client. You see, the problem is trial lawyers and injury victims typically have no idea this additional compensation is happening as a result of the investment in those shares. And that's just wrong, as it drags down the yields for the client for no good reason other than to boost the pay for the RIA, an agent, or some other party. Okay, let's wrap up this segment. You see, there are some less than honorable things happening in the settlement planning profession, which, while not illegal, are confusing to clients and trial lawyers and lead to clear conflicts. I'll be looking at each of those conflicts and problems in future segments, as I said, but until then, if you're an injury victim or trial lawyer, be sure to ask whoever's ever pitching you a settlement plan of any type, what hat are you wearing and who regulates your conduct and your professional recommendations. Till next time, I'm Mark Wallstrom. Thanks again for watching.